3, sir. Page number 1. Page number 1, item number 1 to 3. Page number 5, item 4. Page 6, item 5. Page 7, item 6. Item 6.
That's a matter related to outsourcing Rashmi Das. My Lord, Justice Mahapatra may not hear this matter.
My orders are under challenge.
Yes.
No, my lord's order was subsequent. Subsequent.
This is that Rashmi Das.
Yes, that
Original order.
yes.
Let it be by some other bench. Why I have passed from subsequently orders.
No, it's
connected match.
6. And any other bench where one of us within bracket, Justice Aditya Mahapatra Ji, Aditya Kumar Mahapatra Ji is not a member.
May I pray this short adjournment?
Which matter?
This item 6 any day next week. May
No, it will go to the different bench.
Yes,
Obviously.
ma'am. That I am saying that next week any day.
I am not fixing the date. Let the registry find out and constitute the bench to be taken by this matter.
Mention before the registry for that detail.
Well,
They'll find out.
Page 30, item 7 and 8.
Item number 7, my lord. Lord, that is at court. Manager's matter, my lord.
It is better not before this bench because ultimately I have to write the judgment. Hardly there are days to write the judgment.
That's what I was wondering, my lord, I am unlucky. I would not have taken much of your time. I can finish it up within 15 minutes.
It is easier to argue, but it's difficult to write a judgment. So, my lord, since matter is looking to have some mercy, let it be by some other bench.
We give this matter on 5th of October, Mr. Mohanty.
Madam.
Let the matter be listed on 5th of October. Mr. A. Mohanty will submit the petition. And who is appearing for this, the government side? Who is appearing?
I am appearing. Item 7.
Opposite parties. Next. In all the same matter. Yes.
Page 31, item number 9 to 12.
Item number 12, Your Lordship. This was listed on Monday, 18th. Your Lordship had directed to list on 25th along with the main matter. That is WPC number 17,961.
List on 25th with the analysis.
Here we have not filed the counter affidavit. I pray 10 days time to file the counter, madam.
Which matter?
And this item 12.
Item 12, Mr. Putuli made a mention that Your Lordship told that let the matter come along with the main matter which has been remedied by the Honorable Supreme Court. On that day, he can take adjournment.
So last occasion, my learned friend made a mention that the matter is mentioned.
No, I think his proposal is very reasonable that 125 let the matter come, be part of this batch, and then you take time.
Because this is a different matter and all those matters are remanded by the Honorable.
So, Mudli, that day you bring it to the notice of the court.
Yes.
If you take this court, will grant time to file counter.
On 20. Page mention over.
Can be governed by the lordship because it was heard partly by Justice A.K. Mahapatra or Justice A. Mahapatra. So I am not getting that bench. So in your lordship, please, it's only restoration matter.
You can take small matter.
This was a lordship.
Single bench matter.
No,
Single bench or division?
You are a part of the bench.
I don't know. Special notice.
Notice for
Are you ready with the brief? Are you ready with the brief today?
No.
All right. Today matter will be taken up.
And may I know the time, your lordship?
At the last of this.
Because this is not
12:45.
yes, sir.
For today. Honorable Court directed due to urgency, list the case of press admission, but case was not listed. The matter, subject matter of the case, my lord, only for correction or
Directed to be listed today.
This is regards to the regulation of the government has filed the appeal challenging the order passed by the admitted signatures, where direction has been given to regulate the services of the laboratory technician. Now, the matter is pending. It appeal filed by the government is pending. In the meantime, my lord, they have advertised to fill up all those posts. So, your lordship directly today, may I pray maybe taken up tomorrow or day after, because otherwise they will fill up the post and will use support tomorrow.
So I'm filing the petition today because that is an application of attachment and execution. I have challenged in the petition the lack of jurisdiction of this honorable court to appoint an arbitrator. Let it come up tomorrow night.
Okay, which matters?
There is an arbitration, an arbitrator was appointed. Now I am challenging that this honorable High Court doesn't have the jurisdiction to appoint an arbitrator on the basis of which it proceeded.
Did you receive the notice from the arbitration proceeding?
No, my lord, the notice was issued at arbitration procedure ex parte. And still thereafter, before that also I have filed a writ petition over here. And my
Always it will be listed in the first week of October, not
because that's an apprehension. Let it come out tomorrow. I will not take more than 2 minutes.
It's not possible. It will come.
Should I free? It will come Monday. I will not take more than 2 minutes.
Let it be Monday. Let us see.
Today, if it was not listed, may I say let it be listed on Monday next.
All right.
My lord, one matter. Just the lordship's direction to it has required to be listed on not listed. Present my lord directed listed to the pass. Listed.
No, let us see. Bring the file. Huh?
It's not matter how this compromise my lord also hard this matter. When my lord sitting as urgency, can it not wait? No, that is the urgency. Urgency because they are also violating their compromise. They agree the compromise.
Oh, that matter.
Yes.
This will not come. It will go to the first week of October. It will take.
May I interrupt?
Well, it's in that the loan has already been sold off, my lords. We'll be needing instruction in that regard. The bank has to be substituted. So let the matter come, my lords, after 6 weeks. Our counterpart, my lord, senior is also there, my lord.
The matter will be listed on 18th of October. Is tolerant?
Oh, I'm sorry, my lord. There is no entry.
I may be pardon, lordship.
Just 18th of October.
May I with the lordship?
There is no entry.
In that matter, my lords,
It is named reflect.
if they are praying for 6 weeks, can it be after the pujas? 8.
Okay. November
They want
14th.
6 weeks, so it can be after.
November 11th. November.
Yes. November 13th.
13th November.
We do appearances in a scale.
Yes, Mr.
Lordship W. Well, as super losses kind.
Urgency involved in this matter is that I was the opposite party member in the writ petition, but without any notice that was disproved of, directing the sub-collector to take the demolition process in the law. Because I have donated 40 decimals of land to the government, that was not brought to your kind notice of a lordships. So your lordships may kindly be taken up at any time.
Today it will be taken up.
No, your lordship is sitting with the Honorable Justice Savitri Rock.
Oh, then
So it can be on Monday, your lordship.
May I with the lordship kind.
This
is a PIL, your lordship, a school, primary school, your lordship. It has been given accordance, but on fake documents, and those students who are passing out of that school, your lordship, they are not getting admission in any other school, and it is up to class 8. So thereafter, they go to any other school. There is no attendance record and nothing. There is a order of the elementary education department also, your lordship, but thereafter also, this is not being taken care of, your lordship.
It will come on Tuesday.
May I take
Because, your lordship, there are other schools also.
You should be worried about your school only.
No, your lordship,
Schools are agreed. They should file separate writ application. Why in a PIL? You can always appropriate bench, assigned bench. Instead of filing a PIL, you approach the appropriate assigned bench for your cause. Why are you espousing a public cause? You are only concerned with one school only.
Let's bear with
Number 684.
kind permission to mention two petitions by Lord Chief Justice sitting with Justice Sabitata disposed of one in the month of July and another in this September, my lords. My lords, in lawsuit directed to the petitioner to comply certain
Already looking to give
but
them.
the orders have not been uploaded.
I know 50 orders are still lying with.
My lords. I'm giving the
Another matter, Your Lordship, not before Your Lordship's vote today. It was directed
Obliged.
to taken up since 12th, Your Lordship, writ appeal. It has not come. Only thing is that the respondent is 90 years of old and is ailing, Your Lordship. Can you tell me next week, Your Lordship?
Not next week, 5th of October.
5th.
5th of October.
I may be.
Two recapitulated, one page and other Your Lordship specifically proceeded to today. I pray this matter to be taken up next week.
Miller, may I take your lordship kind permission to make a mention, Miller? 25 above staffs of a technical institution, Miller.
No, including that, you can give it to me.
Miller, they 25 above staffs of a technical institution, Miller, they seeks to challenge the government, present state government motion to upgrade that institution into a private university and handing over to a foreign citizen, Miller. Miller, in violation of the 11 judges constitution bench judgment, Miller, it is the fundamental right of the citizen of India as per Article 19G, Miller, that was not at all taken into care by the government. Now the opposing staffs, Miller, they have been prevented forcefully to enter into the institution. Because the assigned bench, Miller, assigned bench, the problem is that, Miller, you Lordship may kindly appreciate, the assigned bench is court number 3, presided over by Honorable Justice Dr. Sarang Miller. Miller, his Lordship requires the correcting matter, Miller. It is arising out of this matter. Your Lordship may kindly see. Assignment of bench. Yes, Miller. The assigned bench, this is the recusal matter, recuse of the Honorable Justice Dr. Sarang Miller. Miller put up this matter, of which one of Dr. B.R. Sarang is not a member, Miller. It is the assigned bench. That's why I have been compelled to make a mention. The side should be placed before the Honorable Chief Justice. Miller.
So we will look into the matter in the administrative side.
Miller.
The problem is that the proposition of law you are espousing may not be applicable in the present case.
Miller, your Lordship may kindly appreciate and wonder, Miller. It may be
Look into the matter because
That length by Your Lordship and sitting with Justice Savitri Dr. Matter relates to imposition of cost and first disallowing the conciliation proceeding matter. Imposition of cost of 25,000, disallowing the conciliation proceeding. There is a question of maintainability of the writ appeal which Your Lordship has heard at length, my lord. Lordship directed the matter specifically to come today, my lord. I made a mention before deputation bringing it to notice.
it will not be possible because
On Monday, my lord.
That bench is not there today.
On Monday.
All right, Monday. Let's see.
Monday, my lord.
I mean,
To make a mention at 10:30 so that matter could be taken at 2 p.m. my lord.
All right.
Lordship, my present mentioning matter was listed on 14th of this month.
Okay.
And on that, Lordship, according to Lordship specific order, it was listed for today. But today it is delisted. But my urgency of this matter is the execution process has been stayed by this honorable court. So this is a micro industry and it is on the verge of closing its down business. So Lordship, it may be taken up tomorrow, Lordship. I may pray.
Tomorrow is not possible. It will come on Monday.
Monday, Lordship.
I will pardon my lord. That is the first writ appeal matter, my lord. In this case, my lord, the challenge the order of single judge. The learned single judge held that, my lord, there is a clear violation of principle of natural justice. Regarding the suppression of fact, the matter has been dismissed. I have cited, my lord, identical case that has not been discussed.
It will come on 5th of October.
My lord, next week.
It is not available.
And I will
October next month.
permit, my lord. Only the appeal I filed today, my lord. Whatever happened in this case, single judge dismissed my case, but Lord and trial court, Grand Panchayat matter for declaration of Sarpanch. So the Sarpanch has been dismissed. I have been declared as a Sarpanch because of elected Sarpanch, separate the matter tax. She has a criminal case and she is working in the government service and she is a dealer. But suppressing that part, she was elected with the Sarpanch. Trial court dismissed with the elected Sarpanch and declared me as a Sarpanch. I am with charge. Therefore, appellate court dismissed it, allowed their appeal and dismissed my. I have came before a single judge. Instead of 39(2)(a) of the Gram Panchayat Act, to decide this matter on 11B, so which is a total violation of the Gram Panchayat Act. I have filed the writ because on 23rd she will took charge from me. So I pray my lord may take up today or tomorrow. Whatever your lordship.
The matter will list tomorrow.
Tomorrow.
My lord, matter was listed before one and single judge. He has passed an order on 20th October 2022. It is a PI in nature. So matter will be listed before the assembly.
Passed by the learned single judge?
On 20th October 2022. If that matter was not listed till now.
I'm not getting you.
How can it be listed on the orders of a single judge? What was the subject matter?
Subject, that is Jogan Sahayak. Jogan Sahayak has collected the money by selling the Gondiak and other articles. But he has not deposited that amount in the bank.
So how that is fair?
My lord, Justice Mr. Biswanath Mahanti has passed that order. Biswanath Mahanti. My lord, another matter.
Just a minute.
My lord.
What is the order?
Order copy.
Order is not uploaded. That is available in the record only, not uploaded. That is order on 22nd October 2022. My lord, this is the another single bench matter. As per the request of the Law and Government Council, chance has been given to file the counter on 15th December 2021. And the matter will be listed on 21st December 2021. Despite to file the repeated counsel memo, that matter has not been listed today.
Mentioned before the single judge.
Well, I have mentioned before the single judge, but it is not listed.
Yeah.
Pardon the mention, Your Lordship, it's a fresh PIL.
Yes.
Relating to illegal construction of road in Gram Panchayat. Fresh PIL, Lordship.
Already Monday it will come.
I do place. Lordship, this Mata matter was before Your Lordship and before Honorable Justice Savitri Rathore is pertaining to computation of maintenance, taking into consideration the payslip of April 2022, which the family court had called for. But without considering it, the enhancement was done. Lordship had already, the counsel for the respondent had sought for instructions pertaining to that affidavit, which has been filed before the Honorable Supreme Court, which I placed before Your Lordship also.
So it has not been listed there?
Not been listed. 16, it was specifically directed. I made another mention.
After 5th of October.
Let it be listed before Your Lordship.
Time is not there.
Lordship has heard the matter. It's
I know.
For
that is why I immediately read the matter. All right, let it come on Tuesday. Let us see.
Tuesday. Grateful.
May I have my lord's leave kindly to mention item number 9 in today's lordship. Lordship, this is a matter where if lordships are pleased to pass a partial stay order because the other side has taken order, final
wait, let it is on board. Item number 9. That wait, let us see.
Yes, lordship.
Yes.
I may be pardoned to mention this matter. It was heard at length by my lord, along with Justice Ms. Rathore. In the small matter, statute has been challenged and pleadings are complete. It is that only due to hardship that matter Your Lordship may recollect. Only for hardship, one will be given promoted. Although similarly placed, the petitioner has not been given promotion. May be taken up on Monday. Previous week also I mentioned it is not in the list. Website it is
not coming because of my congested board, because I have to manage after all the board and pass.
Yes, I do understand. 5/9 also website it is the date has been shown as 5/9. It has not been listed. Twice I have given memo. If it is possible on Monday.
Do we see in Tuesday? Let's speak.
Any?
I may pardon my lord. Item 6 that was adjourned, interim order to continue in that case.
Item number 6, interim order, if any is passed earlier shall continue. Yes.
Roll call. Yes, admission item number 1.
But here, there are 3 matters before your lordship.
Yes.
I am seeking review of the order passed by the previous division bench, wherein the Honorable Division Bench said that it has become infructuous. In fact, it is not infructuous. Your lordship may kindly see my prayer in the writ application. My lord, here in the Nabakalavar, there was a notification by the government to acquire certain lands. We were the first persons whom the land was taken. We were the shopkeepers under the mutt. Then 3 phases of acquisition was done. In the second phase and in first phase also, compensation was granted to the land losers. Here, my lord, my prayer in the writ application was for quashing the 11 notification under the Right to Fair Compensation Act. But now much water has flown down, so that question of quashing of section 11 notification does not arise, because already constructions and all has been made. But here, my lord, I had approached your lordships previously, wherein it was on the preliminary notification. This Honorable Court did not incline to interfere. I went up to Honorable Apex Court. Honorable Apex Court that you challenged the final notification under section 19 of the Act.
Yes.
I came down and challenged that order. My lord, now final notification is also there and much constructions developments have been made. So, my lord, that portion, in fact, nothing remains.
This one thing I tell you.
My lord.
They will dispose of this review petition with observation since the fresh cause of action has arisen. You can file a fresh petition.
My lord, in fact, it can be disposed of with a small prayer, my lord. Your lordship may kindly see this document for a moment. Without a mullah, he could my lord, here, in similarly placed persons, that was from Uttar Pashchimatho, that is review petition number 84. That is regarding Uttar Pashchimatho, this is Chansata Matho. We were the tenants under this much. There is no dispute on that fact. There, my lord, they have granted certain compensation regarding one-time reallocation allowance. A rental they have given for 10,000 per month for 18 months or till they hand over a showroom, and ex gratia certain amount. If they reconsider on this line also, my lord, it will suffice my cause.
Problem is that this is an appealable order.
My lord,
this order is an appealable order.
they have not passed this. They have done under the Acquisition Act. They have given to similarly placed persons who will be much.
Yes.
I have not been given. This is my entire grievance, my lord. My grievance was I was asking in the writ application for grant of 5 lakhs as compensation, which my lord they did not give. They have assessed something.
Why you should exercise our jurisdiction in a review in particular?
Because my writ application doesn't become infructuous because the compensation portion was never given to me.
No, therefore you are granting liberty.
My lord, that is
a subsequent cause of action. Why should we take cognizance of this?
My lord, that's
You are the authority.
that much your lordship said.
That is your
Yes, your lordship said. Constitution. Let them consider my case and it will.
all right. That
Whatever grievance you have, you raise before the authority.
and the next 3 matters are also like
Same manner. Same. Taking into this consideration, if they consider my grievance, my lord, I have nothing to say.
Whether they are similarly placed persons or not, that is
absolutely not.
that must be direct the authority to examine.
Exactly, sir.
Yes, ma'am. That will do.
Heard Mr. Amit Prasad Bose from the council within the review petition. So, the review petition is directed against the order dated circumstances to take over. Stop. Mr. Bose, council has submitted that the challenge against the notice is issued under section 11 of the Such Act. This is also this Land Acquisition Act.
Yes. 11, 19, both are under challenge, madam. And non-payment of compensation is also my the writ application. The you are not supposed to see the writ application, it is all the prayers are written there. Writ application at page 24, if your lordship may see. Reconstruction, rebuild shop room, demolish shop rooms, everything, all the prayers are there, my lord.
The change against the notification under section 11 of the Land Acquisition Act 1894.
No, it is not. My lord, that is right to fair compensation and
I'm telling you,
13 Act.
13 Act, right to fair compensation.
Only your prayer E survives. according to-
Yes. Prayer E, D and E survives, C and E survives, man.
And stop the demolition of the structures on the proposed acquisition in absence of notification under section 19 of the Act, said Act. It has been further asked that wherever the shops have been demolished, that should be rebuilt. So that the petitioners can carry on their business. Another relief has been sought that the purchase deed, Annexation 9 to the petition, is to be declared illegal in view of the instrument at Annexation 8. So, thereafter, the petitioners had asked this court for payment of compensation to the extent of ₹5 lakhs for illegal demolitions carried out by the state authorities, as there was no rehabilitation exercise before the acquisition. In the course of the hearing, Mr. Bose and counsel has submitted that now the petitioners are not inclined to raise the relief as made in the writ petition if the equal compensation is recorded in the office order number 266 dated 19 to 20, it is 20 is extended to the petitioners, right?
Yes, sir. Because same Chudan Sai, same Uttar Pradesh they have given to others.
Inasmuch as the land that has been acquired from the petitioner falls in the same class, same area, and so there should not be any difference in making the compensation. Stop. As the reliefs in the writ petitions are not pressed in view of the subsequent events, that the total construction has been made and the purpose of the public utility has been served, we do not find any merit in the review petition. However, we find sufficient force in the submission of Mr. Bose and counsel that the petitioner, if similarly circumstanced over the class of land, position of land, are comparable to the beneficiaries whose name is appearing in the order number 266 dated 19 to 2020.
One Surendra Pusti.
One Surendra Pusti. The beneficiary.
That area, Uttar Pradesh.
You just before that.
Yes, that is the same matter.
You go a copy of this order for purpose of future reference. Order dated 19 is taken on record. Stop. We direct the collector and district magistrate Puri to consider the representation of the petitioner, which the petitioners may file in terms of the order dated 19 to 2020 within a period of 6 weeks.
My lord, provided they are similarly placed persons.
That is
what my lord is saying.
Yes.
representation. Only directing the representation, we are not giving.
But my lord,
They are paying.
they
It
can
stand in
claim
a
that.
similar footing, obviously, Mr. Mahanti.
Yes.
Goes without saying.
My lord, my sister is missing that review 84 is of that same month, same Uttar Pradesh.
All right.
That you may see also.
By 6 weeks from the date of receipt of the representation, the petitioner shall file the representation within a fortnight from today. Mr. D.K. Mohanty,
Along with this order, he will
along with a copy of this order,
for
Mr. D.K.
compliance.
Mohanty Land Council has submitted that the similar equitable treatment cannot be made unless all the parameters are identical.
Yes.
However, identical. We have not made any comment of the merit, but we have only directed that the collector and district magistrate shall appreciate the representation for passing the appropriate order, so that by any means the petitioners are not deprived of due compensation.
May I make one more? Your lordship said that all the prayers are not. I'm not
Compensation.
only compensation portion I'm pressing.
No, 5,000 for demolition.
Yes.
Now, demolition, they will pay you. No, that's.
If they play with this compensation, I'm happy with that.
That's why I'm telling you, demolition cannot come unless we declare the demolition illegal.
Yes.
On the ground of this demolition, you cannot get the compensation.
No matter much now.
Now you get this loss of property. That is one of the part of the execution. Yes. Similar order in all the matters.
All the three.
All the
Gratefully.
all three.
Item number 3.
Yes,
My lords.
I think you have already completed.
Yes, sir. Your lordship directed me to find out that what is the document relating to that settlement earlier, your
Yes,
lordship. That I have found out, your lordship. Initial period was, your lordship sees in the memo, 2/95 to 6/95, which is reflected in that order, your lordship. And the notice I have enclosed, your lordship, may kindly have a look.
Yes.
I would have put it.
All right.
Your lordship sees the first page, your lordship. Whereas BD Supply Company, Khetrajpur, OR number 938, an establishment to whom the PF and MP Act apply, have made default in payment of provident fund contribution for the period from 2/95 onwards in respect of 6 number of employees. Your lordship indicated that if the number employees are not indicated or identified, then the entire thing becomes superfluous, your lordship. That is what is indicated in that particular thing. And we identified that, and we also checked that. Then we had paid that amount, and your lordship comes to the 3rd page, your lordship. The settlement, your lordship, this is regarding the resolution of the settlement. This is again by Regional Provident Fund Commissioner. Proceeding under section 7A of the PF and MP Act for the periods from 2/95 to 6/95. Against Mrs. BD Supply Company, code number so and so, regarding the undersigned has been pleased to drop the 7A proceedings from 2/95 to 6/95 after receipt of full compliance and confirmation from the area enforcement officer. So this is complete, your lordship. And that is why we had indicated that since you have made an inquiry and also completed that, how can you make another inquiry for even no employee whatsoever? No indication of any employee whatsoever.
Terms of compromise not recorded. Terms of compromise.
It's not a case of compromise, but it is a case of payment and compliance, your lordship. It is a case of payment and compliance.
Acceptance of the liability.
Acceptance of the liability.
According to them, once the inquiry has been complete, the matter is complete, and why you are starting again for the same period.
Yes. That is it. And
My lord, I will take instruction of that because it's a to me, and I will take instruction that I didn't compromise.
It is a big embarrassment for you because you are supposed to be instructed on this.
Yes, my lord. Just now I am receiving the upset.
It's your document only.
Your document.
You have been well informed prior to the coming to court regarding this compromise. This is by your officers.
Yes.
So if it is compromised, then not compromised, but it is settled.
It is settlement of
Settlement. Yes, settlement. The demand was made and settlement has been made here also. That is the.
They settled it. So the last document you see.
Yes, yes.
This
That has been accepted. Instruction only. Simply instruction so that it can be dissolved.
Well, they may, because next Thursday is a holiday. 21st, 28th.
And we
Next, there it will go up to 5th of October.
Your Lordship, I had heard extensively.
No, that is
Only
why.
thing is that the next Thursday is a holiday, Your Lordship, that I have seen also.
Yes.
I have also instructed. It's a fixed on 27th, Your Lordship, or 26th. For a small time, Your Lordship, half an hour.
Already 27th, make it on 27th at 4.
Yes, yes, yes.
At the request of Mr. Umakant Nistral and at Council appearing for the Regional Fund Provident Fund Commissioner, let the matter be listed on 27th at 4 p.m.
Yes.
So, today, Mr. M.K. Nistral and Senior Council has produced before us
Yes.
the
One more time.
the
settlement.
no, the not settlement actually. The one notice dated 21/7/1995.
Yes. And the order dated 22/8/95.
Order dated 22/8/1995.
1995.
This is order or intimation?
Right.
Some kind of intimation.
Yes, yes. Before 7, the proceeding was continuing.
That
That has come to a halt here also. And dropped.
dated 22/8/1995.
1995.
But this is compared to a particular company.
Yes, yes. No. Similar orders have been there for all.
Mr. Nistral, that once you have settled about the strength
Yes.
of the workers,
Yes.
unless you have specific document that has been increased or anything has happened, or fall below, the owner will come to you, just delist me from the panel.
Yeah.
So it has not happened. But you have to now give the reasons why, how you taken as a new inquiry.
Yes.
And that's all.
And being a statutory
Those are
authority, you
taken
can't
as
take
a
different stands for different assessors.
No.
It has to be a common stand
Correct.
for all assessors.
My lord,
Assuming that this is confined to one case, you have to adopt the same for all. Mr. Mishra is saying that it has.
It is for all the 5 establishments.
It is only for that limited purpose.
yes. My lord, the names of Mr. S.K. Patnaik, senior advocate, and his associates may be deleted so that there is confusion will not.
Oh,
Have this,
council should be deleted as the council for the regional
P.K. Patnaik.
P.K. Patnaik, sorry.
Mr. Mishra's name only, Umakant Mishra.
Now, Mr.'s name only, Mr. Umakant Mishra's name only, name of Mr. Umakant Mishra shall only be shown as a council for the regional program.
My lord, it is 27th,
4 p.m.
27, 4 p.m.
oh,
Yes.
yes, please. Item 4, sir.
On behalf of Mr. Naik, my lord, 1 week after my lord. He is in ICU, man.
The other item, my lord, not the main item.
Last sub-item of item 4. On behalf of Mr. D. Naik.
Debasis Naik is suffering from dengue and admitted in ICU.
ICU.
I don't know.
But in this case, if your lordship will find our affidavit is already on record by the secretary, principal
What
secretary.
to do? Someone council is suffering from dengue.
No, that is not the item. This is sub item, my lord.
No, matters are being hard together.
No, my lord. The main matter is a serious PIL matter about health and life. And the government is not complying with any order of this honorable court.
6109.
6109.
But all
Let me
Earlier, some orders were passed by the then Chief Justice, Dr. Justice S. Muralidhar, while sitting with him. In this case,
yes,
regarding Dr. appointment of Dr. attending the hospital.
last order, my lord.
From the
Please allow me to reveal the last order.
You have given a very obliging order, my lord, for the state of Odisha.
Mobilizing anybody.
Obliging order.
Yes.
It's a constitutional duty.
Everything. Let me.
That order has not been implemented.
No.
So you approach in filing a contempt if they are not implementing that order.
Interim order.
That will be taken care of. Even if it is interim, some direction has been issued by this court, and your allegation that it is not being implemented by the state.
Let me leave
one thing, we are giving you a very short date.
Sir.
It will come on the 6th of October.
Sir.
No,
my lord.
No, my lord, please. You have given this order, my lord. I want that you should final it. Yes, my lord.
Days are numbered. Understand the difficulty. Days are numbered. There are holidays also.
No. My lord, your lordship may ask him which order he wants. There was a direction. We have filed the affidavit of the secretary herself has filed the affidavit, and the matter is posted today. That he has not. I think he has not filed any response to the affidavit of the secretary. You have filed, but no copy has been served.
A copy of that affidavit.
Yes. No, affidavit copies are rejoined or service copy has not been served.
Let me read the last order.
Reply to that affidavit.
Yes, I have replied. They have not given the roadmap. But you reply.
Yes.
Let me read the last order of mine.
I have given an exhaustive. Your lordship may see 6th July 2023. It's a very big
chunk of that affidavit.
6th July.
Have you taken any remedial measures or you have stopped the time?
Let me read the last order, my lord.
Yes.
Para 3.
Yes.
We are constrained to observe that this said affidavit filed by the state does not contain any roadmap for improvement of hospitals in state of Odisha. There are several categories of hospitals operating for the health care of the citizens. The government hospitals are open for all, rich or poor. Anyone may come for service from these hospitals. A serious allegation has been labeled that even in the hospital premises, some agents of the private hospitals are alluring people, and in some cases, the patients are pressurized to get admitted in private hospitals. Then, in the affidavit that would be
in response to this order, affidavit is filed on 26th July. Your lordship may have a glance. 6th July. The Secretary Health and Family Welfare has filed affidavit in response to this particular order, referring this order.
I have no copy.
26.
No, you have to.
You are saying that you have given reply to them. Now you are saying I have not received the copy of this. Then I am serving copy of this affidavit.
No, don't confuse. Whether then give that copy to the
there is a one there you have filed, Mr. Mohanty, on August 1st August 2022.
No, my lord, 6th July 2023. Affidavit of Sariti Petition.
My lord.
6th July.
Yes. Is
it last?
This is PI matter. We are avoiding the court.
We are taking up them.
My lord, you get them two suggestions. Their own that and any law, if they can do to prevent the violence in the court. They are avoiding this.
You have filed on 7th July.
6th July.
6th July.
Yes.
Have you received a copy of 6th July affidavit?
No.
Tell them to serve a copy on him. Let him go through that affidavit. Let him file his reply to that. What steps you have taken?
They have dealt with this our order also, and what initiative the so-called roadmap they have just laid down in this affidavit. Why you have not supplied a copy to the?
My lord, my record shows that it is supplied. He is saying that it is not supplied. I will right now I am giving it.
All right.
Let it come on Monday.
Sunday.
Monday. Say Sunday. Then I have to.
He has directed me not to open mouth. He is saying that this is a PIL only. What you know,
my WhatsApp also knows it.
Please.
Please.
Just to look at the affidavit, whether you can file an affidavit by Monday, then we can take up the matter on Tuesday. Look at this affidavit. They have given a details what they are doing, what they are planning to do. All right.
But let me give two copies of the judgment of Honorable Apex Court in 1996. Kindly take it. And my suggestions were based on these judgments of Apex Court.
Yes.
That was given to all states.
That actually virtually made the right to get the treatment from the government hospital a fundamental right, almost to the standard of the fundamental.
So I kindly note, in front of the court, I am supplying a copy.
All right, Mr. Chittaranjan Mohanty, the petitioner in person, has stated that he has not received the additional affidavit filed with the opposite party number 1 on 7th July 2020.
7th July. It is noted 6th. Anyway, 7th.
Because it is stamped with 7th July.
Oh, we have filed it, or next day it is stamped?
7th July. So, Mr. D.K. Mohanty, Regional Government Advocate, has immediately supplied a copy of the said affidavit to Mr. Mohanty. So at the junction, Mr. Mohanty the petitioner is for a very short accommodation for filing a response if required. Let the matter be listed on this Tuesday, 26th. The response, if any, shall be filed by 25th of September 2023. So Mr. Mohanty has also referred to us the judgment in Paschim Bango Khetmuddur Shamiti and others versus State of West Bengal and another colon AIN 1996 is C2426. Stop. We are getting a copy of the same judgment on record. So you also go through that judgment.
Yes, yes.
There are certain the slip of
that judgment reference to
These are in the order he had mentioned, so that
that order.
No, the order he made the mention of the reference.
Yes. It has been mentioned in today's order.
Yes,
Otherwise, you can do a copy, get a photocopy of this order.
Now I'm giving.
He will give.
All right.
Now I'm giving.
My learned senior friend will give it.
All right.
You go through it and pass it on to your secretary also. Let her go through it.
Yes.
Like this will give an idea
Yes, ma'am.
how
Yes.
to go.
Yes. Item number 5. That sub item, your lordship may not tag it because that is Mr. Nayak is there. This other item which is tagged with this health department.
Let those matters come. We will not pass any order.
Okay,
No.
on that day,
Oh, it is been
Because-
reported that Mr. D.K. Nayak,
Debasis now,
the council appearing for the Court of Municipal Corporation.
CMC.
Court of Municipal Corporation is unwell and is not attending the court. Okay.
It is in the other item, sub item, second.
Other items.
I gave the copy, my lord.
All right.
Thank you.
Item 6.
Item 5.
Oh, fine.
Nice.
On behalf of Mr. Nayak, my lord.
In this case, Mr. Naik's presence is badly required because it is squarely CMC is the party is to respond all this. It has to be.
This is that road.
No. PIL. No. This is second one, my lord.
I have got small prayer to make in this case, my lord. I am appearing from my petition, sir. I am the petitioner in this case. There is a direction of this honorable court that the opposite party number 1 and 2, that is the state, meanwhile, the proposed response affidavit shall be filed. May I pray, my lord? Let the matter be adjourned and the state may be directed to comply with this order. They have to file the response affidavit. That is in para 5, my lord.
That CMC was supposed to give.
No, opinion number 1 and 2. Proposed response affidavit. Only because representation has filed before the RDC.
Lords may give me 3 weeks time. I will examine that order, whether we are to give any response.
No, we have filed
because the filling up of these water bodies,
my lord,
doesn't exclusively on the matter of the corporation. It comes about this Land Act. Because the conversion is not permitted.
Yes, my lord. So far as my knowledge goes, there is a committee. That is by virtue of the judgment of this honorable court. And RDC is the chairperson of that committee. And they will decide that which Jalasha is to be converted as homestead or
The
not.
allegations of the petitioner is very clear. They say, without any permission, these are getting filled up. And
Illegally, some ponds are
this is the one part of the allegation. Other part of the allegation, when you are granting the permission, you are not making the proper assessment whether that should be granted or not. These are two sorts of, as I understood from their allegation.
My
So
lord,
you file a reply, you are granting.
No, I will give replies.
One is permission part, other is execution.
Yes.
Orders are not being executed.
My
You
lord,
are allowing people to fill up
my
this
lord,
form.
give me three weeks time.
submit before your lordship.
Yes.
The representation file before the RDC, my lord. Our grievance that.
It's okay. I will file the
The
response.
state has to give reply, my lord.
RDC being the chairman.
RDC is the chairman of the committee.
With the
Order dated 11th September 2023, no response affidavit has been filed as yet. As a last opportunity, we direct the opposite parties, particularly the opposite parties of in the revenue department and the Court of Municipal Corporation, to file their response affidavit invariably by 18th of October 2023. It is made absolutely clear that if the affidavit is not filed, this court will be persuaded to give an adverse inference for passing the appropriate order for enforcement.
Sub-item is
Mr. D.K. Mohantil, an government advocate, has appeared for, you are appearing for few respondents. You are appearing for whom?
sub-item. I am the petitioner.
You are for the petitioner, sub-item.
Gokulananda Mahapatra.
Same connected.
Oh, both are same. Mr. Mahapatra has filed for a particular point, and this is a large scope.
5-6. 1-2-5-6. So it has been reported that Mr. D. Nayak, who is appearing for the counsel appearing for the Court of Municipal Corporation, is unwell and is not attending the court. You are appearing for whom?
Or petitioner.
It's for the petitioner.
Petitioner.
Connected matter. The same order, change of the name of the petition. All right, come on.
Item number 9.
I'm for the respondent. I'm for the condemnation of delay. I from the appellant. On her prayer only, it has been posted today. Yes. Who is the council?
Item 9.
Last occasion, she was doing on BC. Yes, she was there. The mention of she was, yes. She's there. Yes, she has
My
come.
lord. My lord. My lord, I am for the appellant in this matter, my lord. The respondent, the private respondent lordship, he was accused in a criminal proceedings and he was subjected to disciplinary proceedings.
I think limitation matter should be taken. Because there is 330 in the law.
On 18th of August, and it is disposed of without serving us a copy of application even and without giving the chance to show cause lordship. And the officer has been allowed to join in terms of the order passed by the Honorable Single Judge. And regarding the back wages only, lordship, let it be tested, lordship, because public money is involved and he was what rate
Mansi, that I think they have already reinstated your. They have reinstated, but only see the order merit they have passed flag C merit, flag C. They have flag C of the affidavit by the counter reply. Yes. Objection.
Annexure A.
My lord, the reply they have not given the copy to us, lordship.
Yes, sir.
Even though, lordship,
Send a mail to her.
Reply has been sent, they are claiming that through your email. Check your email, Ms. Gurgutia.
Annexure A, my lord, document will say, or document. Lordship, kindly see page 9 of that, my objection affidavit, page 9, flag C. Last para 4, my lord.
Yes.
In persons of the rights of the Honorable High Court of Orissa, to every section of the registered to full backwardness and continue to service subject to condition that registered to the subject outcome of the appeal. But what they have done, they have only reinstated. They have not compared the other aspect. So backwardness and continue to service. They have only reinstated of him. So that part, for that reason, I have filed a content application and this one will go to the that is the reason why we should kindly see the 42.
All right, because they say they have a serious grievance about the full back wages.
Full back wages,
all right. Regarding the full back wages, they want that should be re-examined by this court. First of all, there is one reason they did not notice, they did not given any opportunity to file their reply. These are the allegations.
They have been given opportunity, they have filed counter argument for and judgment for because judgment we have been given notice, file counter argument matter. And it is matter. And honestly, it is very clear, and the judgment is also very clear. That aspect is actually not correct. Not correct. And that is the reason. And you also will find from their own application the manner in which they have delayed. That has not been such type of teacher was indicated. So can you see the application for delay? But also can you see application count? Get 200.
Yes.
I flag you.
This I.
Flag you. My lord, Lordship, kindly see that they have given a date chart. Page 4 of the, page 3 of the petition. My lord, page 4. Date of that. My lord, Lordship, kindly see the date of judgment is 1/11/22. So it's got it, my lord?
Yes.
Writ petition allowed by High Court by order directing the applicant internally to boost the petition and to service with the continuous full backwardness. 7/11/22 communication by the person to the applicant. But 21/11/22 the person allowed to join the compliance of in compliance with the schedule passed within. 22/23 allowed to 3 months after. The legal opinion was sought from the London DG for further steps to take in the matter. Then 22/23, the DG communicated the opinion after considering the relevant documents. Then next page, 13th provisions and there is a legal opinion, but was put up on several days for further clarification. 26/4/23, considering legal opinion given by the DG competent directed to process the file for filing appeal. 8/5/23, file was forwarded. And 10/4 legal section was prepared for draft to appeal. 2/6/2023 appeal was given by the appeal was given 7/2022. But this kind of attitude has been deprecated with the Honorable Supreme Court ultimately filed in August 23. All these things are very casual good, and you will find the if I also permit me to
Mr. SS Mahapatra was appearing for NCP.
Yes,
it has been noted in the judgment.
The council,
the judgment, it says SS Mahapatra and council appearing for the NCP.
I don't know.
Sorry, the wrong statement.
The wrong statement. And my lord friend is the council.
In any case, Ms. Gurgutia, even if we grant you opportunity now, how you are going to improve upon the case? You have been acquitted in the criminal case, disciplinary proceeding has been dropped. So necessary consequences will follow. You have to reinstate with back.
There is no complaint fiction.
Lordship, the disciplinary proceedings have not been dropped. Lordship, if I
that is what they are written in the judgment itself, taken note of by the learned single judge.
No, Lordship. Lordship,
So
that is
fact
the
wrong.
problem,
Up to
Lordship. Lordship, I will show through the documents only, Lordship. Some parts recorded factually also are unfortunately not recorded properly as per the documents. They may not be proper display by the learned counsel or anything might have happened, Lordship. But I have documents
The impugned judgment of 1st November 2022 itself reveals that he was acquitted in the CBI case as well as the disciplinary proceeding was dropped.
Lordship, disciplinary proceedings were not dropped. He was punished. And thereafter, Lordship, the criminal proceedings has been closed. That doesn't mean, Lordship, it has been decided by the Honorable Supreme Court and this Honorable Court also. That doesn't mean that he has not done any violation of or misconduct in the
disciplinary proceeding against him. Certain action has to be taken. Otherwise, it will be follow that both the cases he have been exonerated. How do you
Lordship,
say?
he has not been exonerated. And Lordship, the money which he took from the person was found.
Really confused. I am getting really confused. What was the outcome of the disciplinary proceeding?
He explained the disciplinary proceeding.
Lordship, the order I have Lordship, Lordship, the internal house appeal house appeal authority has also confirmed the decision by the disciplinary authority punishing him, Lordship. And the CBI, which have
you annexed that order of the disciplinary authority?
That was entirely on different grounds.
Have you annexed that order of the disciplinary authority?
Yes, Lordship. Yes, Lordship. In the main
Order of the disciplinary authority.
Yes, Lordship. I've annexed, may I refer, Lordship. And regarding the service, Lordship, may I point out this gentleman has joined the authorities and he is serving through the internal mail, and which is not available because bulk mails are there, and he claims that he has served the affidavit in opposition. When the learned counsel is there, I am there. Instead of serving me or to the authorities directly, he is sending in bulk spam mails internally. So that is also something to be looked into, Lordship, because he is there, he is getting all the information, and in fact, he is misusing the system, if I may most humbly point out, Lordship. Lordship, if he is not guilty...
You just show us the order in the disciplinary proceeding. The other person go into it.
Lordship.
Where is that order?
Lordship, the annexure A1, Lordship.
Annexure A1 of the memo of appeal.
Lordship, the IA number 4773, that is the stay application, Lordship. The bulkier one, Lordship. Lordship, all the orders are annexed, Lordship. The final order by the appellate authority, in-house appellate authority, headed by chairman, they confirm the
At
order.
what page is your order?
Lordship.
At what page is your order?
Lordship, one second. Lordship. Lordship, the annexure starts from page 50, Lordship. This is the order passed by the learned chairman of the authority concerned, which is the appellate authority, Lordship. And
page, you are referring to page 50.
Page, Lordship.
This is a page 50 is the part of this criminal case.
Lordship, the internal page number, Lordship, I apologize, Lordship, the correct number is
not been properly paginated.
This is 98.
Lordship, I was
No, it's not 98.
paragraph. Lordship, order dated 27 February 2020, Lordship. Marked A5, Lordship.
It is
The page number is.
passed by Dr. Sadbir Bedi. Am I correct?
Yes, Lordship. Deeply grateful, Lordship.
All right. What is your submission on Empal Anthony? This special CBI, special court has this acquitted him from the charge under this section 7 and section 13. All right, and now you are saying that he has taken the gratification.
Demand was not proved.
Lordship, the gratification money was found from his pocket, from his person. And Lordship,
have you gone through the proposition? No, just wait. Have you gone through the Supreme Court proposition in Empal Anthony 1998 Supreme Court?
Yes, Lordship, and thereafter, Lordship,
taken on the same set of charge. If a criminal court takes a decision, that decision will be binding on the disciplinary authority. They cannot go against that finding.
Most humbly, Lordship, in Roshan's case, Lordship, in 2008, I'll give the citation, Lordship. There also the Honorable Supreme Court said that the
Supreme Court says the near some criminal case is over doesn't mean the all misconducts. Right. The word that Supreme Court has stated, all misconduct is waived. That doesn't mean in a departmental proceeding, which was not the subject matter before the criminal court, you can proceed with or you can continue with the departmental proceeding. That is the law Supreme Court has stated. So read the accordingly. Now, while provisions of rules such and such, the gravity of the we stand proof against the appellant is a very serious, that the such and such. The explicitly provides that the case in which charge of acceptance of illegal gratification from any persons is established only with the removal. So you are just dwelling on the same charge.
Lordship, the same charge but in different context because admittedly the money was found from his person.
Yes,
and admittedly
this is the part of section, this acceptance of the gratification and the demand of gratification are covered by section 7 and 13 of the Prevention of Corruption Act, right? That is why mentioning those cases and the criminal court has exonerated from charges. How in the disciplinary proceeding on the same set of charge you can put the punishments? You cannot do that.
Lordship, I most humbly put it in a slightly different, sir. This sets a precedent for if he's left free, Lordship.
We are fixing the matter some other day. We are not passing any order. No. Only that you should not proceed with the concept matter. Right? No. Yes.
But Lordship, in contempt matter, they are going to
we are directing the contempt matter should not proceed unless these matters are there is a protection against you. Yes.
Grateful, Lordship. That has been disposed of. I was just trying to point out. Lordship. Grateful, Lordship. Grateful. In this VC, I could not hear, Lordship. Just pardon me.
I number. That is 4774 of 2023 limitation. Yes. 4774 of 2023.
Lordship.
You have the matter will list again on 9th of October 2023. Stop. In the meanwhile, the contempt proceeding as initiated by the opposite party number 1 shall remain suspended. Stop. This order has been passed without any observation on the merit of the contempt procedure. So we have heard suggestions from the applicant and Mr. Anki Mohanty. Now, senior counsel along with
Mr. S. Senapati.
Mr. S. Senapati, and counsel appearing for the opposite party number 1.
Deep location. Have you filed your objection to that bill application? I have filed objection.
Yes.
Item number they may be directed to serve a copy, Lordship.
Have a copy of that objection. Already said again.
And
Send a soft copy. It will not cost you much. The soft copy is already sent.
Already said.
internally he is.
No, it's not.
Because it is council, not internally. The other things you share with them or your organization email. You can send it to that email. When you are appearing as a council, your email is also the official email for our purpose.
Right.
Next.
Item 10.
Deeply grateful, Lordship.
Sir, actually, this is a litigation of a part of a project, which is at all not necessary. Actually, the road in concern is not at all necessary for the present development. But we accepted that for the beautification of the Manipuri and the greater benefit, but it's with many lots of irregularity. One of which is the payment over the pedestrian payment over the Musa River bridges, for which I have also submitted a rejoinder, of which the opposite party has not yet countered. So, sir, please you will proceed for the final hearing, sir.
Which bridge?
Sir?
Which bridge? Where it is situated?
It is Puri, sir.
Puri, which?
Near Otharnola. I think it is near Otharnola. That bridge, Garuda Stamba is there.
Oh.
Say what to? Again.
That old bridge on Otharnola? That one?
Yes.
So they are not allowing vehicle on that?
No, that is stopped.
Vehicle stopped. So how it is causing problem to the pedestrians?
Sir, actually, it old Otharnola bridge ta stop ହେଇଗଲା ପରେ ତା ସାଇଡ୍ ରେ ଦିଟା ଆଉ ମାନେ ସିଙ୍ଗଲ ବ୍ରିଜ ତିଆରି ହେଇଥିଲା କଂକ୍ରିଟ ବ୍ରିଜ ଯୋଉଟା କି ସାର୍ 2 ଲେନ୍ ବର୍ତ୍ତମାନ ସାର୍ ରୋଡ ଟା ଯୋଉ ଏକ୍ସପାନ୍ସନ ହଉଛି that is for 4 ଲେନ୍ ତେଣୁ 4 ଲେନ୍ ପାଇଁ ଗଲା ପରେ 2 ଲେନ୍ ବ୍ରିଜ ଉପରେ ଗଲା ପରେ ଯଦି ଆମେ ତାପରେ 4 ଲେନ୍ ନବା ତାହେଲେ ପେଡେଷ୍ଟ୍ରିଆନ ପାଇଁକା କୌଣସି ସୁବିଧା ମାନେ ଫୁଟପାଥ ରହିବ ନାହିଁ.
You find out, Mr. Mohanty?
Yes. File counter affidavit. Sir, it is already discussed. And I have also countered the provided a rejoinder, and in which
must be having some standard operating procedure so far these bridges.
That ASI is also involved in this. Your Lordship may see para 5 and 6 of my counter affidavit. Para 5, page 2. That it is only submitted that out of the 2 bridges, one bridge has been constructed in the year 2008. Another has been constructed in the year 2015. The provision for pedestrian strip on this twin bridge has not been provided, as the old Otharnola bridge has been used for the pedestrian traffic. That old bridge is for pedestrian.
That they are not allowing vehicular traffic.
No. In the year January 2020, the old Otharnola bridge has been closed for pedestrian traffic by the authorities of Archaeological Survey of India, Puri. That is Superintendent Archaeological Survey of India has been requested by the Superintendent Engineer Swanso by his office letter number to allow old Otharnola bridge for the use of pedestrian traffic, as it will not cause any damage to the existing old bridge. Copy of the letter dated Swanso that there is no provision at present for construction of a new bridge over the Musa. They want a new bridge. So Lordship may involve No, Your Honor. No, Your Honor. A new bridge is not possible there.
No, but this old bridge for the pedestrian use also has been closed.
That has been stopped by the ASI. That is why I request Your Lordship to notice ASI. ASI is a necessary party in this case, because we can't do anything without the permission of the ASI so far as...
No, Mr. Mohanty, try to understand. We can't also compel ASI. So you have to basically resolve the dispute.
Yes,
they are having some problem. So
Sir,
you
for the, if my responsible submission, if ASI is noticed, then ASI will place before this honorable court. For what reason they are not allowing the
What the good reasons they can provide? Because in the old bridge, there is no pedestrian strip over the bridge.
That is stopped by ASI.
No, the new bridge.
New bridge.
New bridge.
There is no pedestrian strip.
No.
That ASI stopped the old bridge.
Yes.
The situation, what is happening to the pedestrians?
Pedestrians. How will they cross?
No. That new bridge, roads are there, pedestrians are also using. But the main old bridge, which was exclusively used by pedestrians, that has been closed by the ASI.
So why don't you just construct a footbridge only?
No, bridge is not possible. That is my responsible submission. No new bridge.
Beside this new bridge, why it is not possible?
Sir, actually, ASI problem is there. And there
that is, ASI has to give permission. That is
why you have not made the ASI then? If you knew that ASI problem is there,
implement ASI.
ASI has to be implemented. Otherwise, without ASI, we cannot touch anything.
All right, just take down.
Sir, already with this problem.
We have heard Mr. Kalucharan Paikai, petitioner in person, who has pointed out that after the closure of the old bridge over the river Musha, the pedestrians are not have any safe passage to cross the river or to go the other side of the road. Stop. This statement has been supported by opposite party number 1 in their counter affidavit that was filed on
the opposite party number 2
on 8th May. No, 8th. There is when you file this affidavit.
26th July. My record shows so.
26th July. Whatever you record, because it's not 26th July 2023. So in the affidavit, they have stated as follows. The twin bridges. Out of the twin bridges, one bridge has been constructed in the year 2008 and another has been constructed in the year 2015. The provisions for pedestrian strip on the twin bridges has not been provided, as the old Atharnala bridge has been used for pedestrian traffic. In the year January 2022, the old Atharnala bridge has been closed for pedestrian traffic by the authorities of the Archaeological Survey of India, Puri. Stop. Mr. Mohanty Learned Council, Mr. Additional Government Advocate has submitted that the reasons for closing the said old bridge for the pedestrian is unknown to the opposite party number 1. Stop.
Is unknown. No, ASI has directed.
Unknown to you.
Unknown to you, why they have closed?
Why ASI has closed? Must be for safety reason, I think.
No, you don't issue.
This is, I think it's 200 years old.
So by filing
200 years old.
Mr. Paikai Learned Council has stated that for that action of the ASI, there is no provisions of the service road for the locals, no provisions for the service tunnel, etc.
My lord, may kindly note.
In this background, the petitioner has made the following suggestion.
My lord, may kindly note para 6 of my counter affidavit. We have given a letter to the ASI. Yes, that is important.
That 19-7 letter by Superintendent Engineer.
Yes, ma'am.
Has he received any reply from the Superintendent?
No, and there is no further instruction, but it is
take instruction on that. You have written a letter, 19-7.
Yes, whether we have received any reply.
To construct a new food
I have already said
in the Gurupada Square to declare use the road as local, as one of the used exclusively for locals, emergency service and VIPs. 3, to modify the project and to construct a 2-lane one-way ring road, including the old twin bridges at Gurupada Square, and to construct Khandia Bandha bypass bridge, within bracket. The tender has been invited for that project, using the twin bridge as Gurudas Square as entry passage to Puri and Kandaya Bandha bypass bridge at Kumbharapada PS as exit passage from Puri instead of 4-lane in ward number 22 Atharnala area. Stop. These suggestions brings an idea of a master plan, and for which, according to us, only the state authorities can consider whether such master plan can be taken up or not.
Subject to approval of ASI. Subject to approval of
And
ASI.
for that purpose, the Archaeological Survey of India has to be brought in because their approval is essential for taking up such project. Stop. Mr. Mohanty Learned Council has also referred to para 6 of the counter affidavit filed by the opposite party number 1. Stop. In that para, there is a reference of one office letter number 6571 dated 19/7/2023 requesting the ASI to allow the old Atharnala bridge for the use of the pedestrian traffic. Stop. As that will not cause any damage to the existing old bridge. The said letter is available under Annexure A3 to the said counter affidavit. Mr. Mohanty Learned Additional Government Advocate has pendingly submitted that he doesn't have instruction what happened pursuant to the said letter, whether the Archaeological Survey of India has made any response or not, when that is not known to him. Stop. In view of that, we direct Mr. D. Mohanty Learned Additional Government Advocate to file an additional affidavit apprising the court what is the response of the Archaeological Survey of India. That apart, we find it necessary that the Archaeological Survey of India, through the Superintendent Engineer,
Superintendent Archaeological Survey of India, Puri.
Through the Superintending Engineer.
No, only Superintendent.
Only Superintendent Archaeological Survey of India at Puri be made the party, and accordingly, you are the one the other petitioners. Accordingly, the Superintendent Archaeological Survey of India.
Opposite panel 5, he will be present.
Puri, District Puri, is made the opposite party number 5. Stop. The registry shall incorporate the newly added opposite party in the area of parties in the first title. Stop. We issue notice on the added opposite party number 5 to show cause as to why they shall not allow the pedestrians to cross through the old bridge as referred in the order. Stop. Old bridge over the River Mosa, Atharnala. Stop.
Sir, actually, if old Atharnala bridge will be allowed for the pedestrians, that will not solve the problem. Actually, that is very far from the one.
All right. Things we are not passing any order for the time being.
My lord, in fact, there is another new entry to Puri town now, Sri Setu. That is 99% of vehicles will come through Sri Setu and directly will
pedestrians crossing
pedestrians.
The matter being listed again on 18th October 2023. Petitioners steps for service of notice on the opposite party number 5 within 3 working days from today.
DHA can accept it. Deputy Solicitor General, Mr. Paddy.
Where is he? No, he's not.
Solve a copy on them.
He can solve a copy to DSG.
All right, this part serve notice. Huh?
Actually, yes, okay,
solve a copy of the writ petition on Mr. PK Paddy. DSGI ତାଙ୍କୁ ଗୋଟେ କପି ଦେବେ।
By serving a copy of the writ petition with
yes sir actually for proposal 3 टा जोटा अछि रिंग रोड टा सेटा को जदी एक्सेप्ट करने मतलब एतर कोनोची प्रॉब्लम नाही तो बाकी सब समस्या रो समाधान है all the problems will be solved
Lord, one day will come that way, and this will be only for pedestrians. We will not allow any, that day is coming, because otherwise there is a heavy
Bring
traffic
it on
loss.
record. File an affidavit
Yes,
to that
yes,
effect. Bring it on record.
All right.
If that is your plan, you bring it on record.
No, that
This will be exclusively used by the pedestrians.
Yes, the date, your lordship has.
18th October, no? 18th October.
ଗୋଟେ କପି ଦେଇଦେବେ ମିଷ୍ଟର ପାଢୀଙ୍କୁ ରିଟ୍ ପିଟିସନ ହଁ ଆପଣ ଦେବେ ରିଟ୍ ପିଟିସନ ଗୋଟେ କପି ହଁ ଡେପୁଟି ସଲିସିଟର ଜେନେରାଲ ମିଷ୍ଟର ପାଢୀ କିମ୍ବା ଏନି ଅଫ ଦ ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କାଉନସିଲ କୁ ଗୋଟେ କପି ଦେବେ
sir ତାଙ୍କର ଆଡ୍ରେସ sir
ଏଇଠି ଓକିଲ
ହାଇକୋର୍ଟରେ ତାଙ୍କର ଅଫିସ ଅଛି
ଆଜ୍ଞା
ହଁ ହାଇକୋର୍ଟରେ ତାଙ୍କ ଅଫିସ ଅଛି ତାଙ୍କ ଅଫିସରେ ଦେଇଦେବେ ରିସିପ୍ଟ ନେଇଯିବେ ତାଙ୍କୁ
sir actually ମୁଁ ପୁରୀରୁ sir ବିଷୟରେ ଇଏ କରୁ sir
ନହେଲେ ତାଙ୍କୁ ପଚାରିକି ତାଙ୍କର ଇଏଟା ଦିଅନ୍ତୁ ଇମେଲ ଆଇଡିଟା ତାଙ୍କର ନେଇଯିବେ ତାଙ୍କ ଅଫିସରୁ ତାଙ୍କୁ ଇମେଲ କରିଦିଅନ୍ତୁ
sir
ନୋଟିସ ନେବାକୁ ପଡିବ ଡେରି ହବ
ହଁ sir ଆଇଡିଟା କୋଉଠି ପାଇବି sir
ଇମେଲ ଆଇଡିଟା ଆପଣ ପାଇଯିବେ ନେଟରେ ସର୍ଚ୍ଚ କରନ୍ତୁ ପାଇଯିବେ ଥିବ
Item 11. Item 11, your lordship may kindly have a glance to the order dated 30th October. Yes, I have received the copy. Here, the your order dated 38/2023 may kindly have a glance. But the counter affidavit which has been filed, that no reply has been furnished to that, reverting that. With regard to compliance of section 3A and rule 4 of the Odisha Government Land Settlement. Affidavit dated? That affidavit was 12th of September 2023.
If any shortfall is there,
it has not come on record.
No, it's not scanned. Maybe it's record.
Hard copy does
hard copy.
Not. When have you filed it?
12th September. That is filed through email mode.
Something has happened. You just check up, Mr. Manti.
Yes, my lord. My respectful submission, let him file a rejoinder.
No, rejoinder is not necessary because my submission that the order has not been replied with.
Then that
you have received a copy of that affidavit.
I have filed the affidavit.
You have filed that?
Yes, my lord.
You take instruction on that?
Yes, you filed the rejoinder to that.
You file your reply to that also. No, my lord, on the main application, if you think according to you, it can be resolved on the basis of that affidavit, you file your reply. So that can be heard. Not of necessary order can be passed.
That will be have more clarity.
I have received the affidavit has been filed, but my submission that affidavit is not in term of the order. That is only.
That you mentioned in your
No, how it is not, you have to file an objection to that. Written objection that it is not in terms of this order because of these reasons.
Yes.
So bring it on record, file an affidavit.
It has been stated by Mr. D.K. Mohantil and a regional government advocate. These opposite parties have filed their counter affidavit. The counter affidavit is not available in the records.
Filed on
12th September.
Filed on 12th September 2023. The registry is directed to search whether the counter affidavit was received by the counter affidavit is received. If received, the said counter affidavit shall be placed on records. Mr. D.R. Mahapatra and counsel appearing for the petitioner has submitted that the respondent, opposite parties, has not complied the order dated 30th August 2023, whereby we directed the no, there is no any further directions, only complying. We asked them, whereby we asked them
to file affidavit with regard to the provision of 3A, the Act Section 3A and Rule 4.
Whether the road whether the proposed road has been, if the response is not available in the counter affidavit, We direct the opposite parties to file an additional counter affidavit for demonstrating that before the decision was taken for constructing, the decision was taken for construction of the said road, the provisions of section 3A.
3A of the section 3A and rule 4 of the rule.
Section 3 of the said act and the rule 4 of such and such has been taken care of. Okay, let us see what they come.
Your Lordship mentioned that the road, that is not the road, that is Gramo Khora, Your Lordship mentioned.
What is the Khora?
Gramo Khora.
Communal land.
Yes.
Gramo Khora. A communal property.
Then earlier order we have referred is a road.
Yes, yes. No, that is the Gramo Khora, Your Lordship.
This Gramo Khora has been acquired for the purpose of construction of a road.
No. That is what you are saying. Gochar land has been acquired for the purpose of Gramo Khora.
But then Gramo Khora is a communal purpose.
Gochar land cannot be. Except grazing of cattle, it cannot be. And if is there,
is not changed. User, the Gramo Khora also the cows will come and graze there.
Cattle shed basically.
Paddy shed. But he is saying that you cannot do anything unless you change.
Gramo Khora, the first time I am hearing this.
Many things you will hear first time.
We file an additional
Grazing cow, cattle,
fixing it up to this point in the order. Okay.
My Lord, your Lordship is fixing it. Date.
What is the date, please? It is not fixed. Let the matter be listed on 11th of October 20.
My Lord, 18th of October.
18th of October.
Order copy may be copy of this order.
Copy of this order is served to Mr. D. K. Montil and its answer. The Asian government educated came to be state of the parties. And so, well, you ask them, that you have called them to come at 12:45.
For us, they have to come. State she must be there outside. Find out.
Can I see the file, my Lord? Because I have not the file.
I'm a copy so let him go.
This is a restoration petition.
Sumapatra, your matter.
Yes.
This was a non-prosecution.
State is not a party. Hey,
the notice has to go.
They have to take notice.
So we are issuing notice, Mr. Mahapatra. Yes, if take the steps. Heard Mr. S. Mahapatra. And senior counsel listed by you, Mr. Raut.
Myself, Mr. Panda, P.K. Panda.
Listed by Mr. P.K. Panda and counsel for the applicant.
Mr. V. Raut has expired because that's why a matter of that.
There is an application for the restoration of WPC number 8794 of 2008, which was dismissed by the order dated 6th December 2021 for non-prosecution. So, for non-appearance, for non-representation on 6/12/2021, when the matter was, when the petition was taken up for consideration, some causes have been assigned. Issue notice as to why the said order dated 6/12/2021. Oh, there is a huge delay. First, no, just score one. Hard much suggestions.
Limitation.
There's an application in Section 5 of the Limitation Act for condoning a delay of 598 days in filing the restoration petition, recalling the order dated 6/12/2021 as passed in WPC number 8794 of 2008. So, issue notice as to why the aforementioned delay shall not be condoned or any other orders shall not be passed in the circumstances of the case. Notice is made returnable on 13th November 2020.
Well, I'm willing to take by special messenger. I'm praying for taking the notice by special messenger to serve the opposite parties.
No, take by because it creates a lot of problem.
Shortage of staff is the method.
Because we cannot provide.
Okay.
All right. We are providing. So then says steps for service of notice on the opposite party. There's three opposite parties. For service of notice, steps for service of notice shall be taken on the opposite parties by registered post with AD within 3 working days. So the petition is also given liberty to come.
My lord, on the last occasion, your lordship, I have explained and demonstrated how the matter is pending and complete procedure has not been completed as required under section 19 to 25 of the Wildlife Protection Act, my lord. And it is also admitted by the Forest Department in their counter affidavit that section 25 has not yet been completed. Section 26 has not been, it is pending. So therefore, my lord, since I could not place the matter, I was not available on that day, on the relevant day on 22/9/2022, this honorable court has held that since the notification has been issued since 1st September 1987 under the Wildlife Protection Act, demarcating the boundaries of the Balukhan Konarka Wildlife Sanctuary, these notifications have held the field for well over the 35 years now, my lord. But the fact remains that after this notification, by the orders of this honorable court, a inquiry was conducted. And
Mr. Raut, when did you acquire this property?
My lord?
When did you acquire this property? After the notification of
my lord, it is my forefather's property, my lord. It is a PIL, my lord.
I understand.
PIL, and what has happened, my lord, by virtue of this notification, all the rights of the my lord lands have been curtailed.
But see, Annexure 1 doesn't.
My lord, there are several lands which have been purchased, my lord. But the fact
you are referring to one right now. Yes. Annexure 1.
My lord, Annexure 1.
When did you acquire it?
My lord, these properties were acquired, my lord.
In 2010. Much after the notification.
My lord.
Yes. So,
my lord, it is. I have given that property description because he is a resident of this area.
No.
I find it.
You have to first say whether these properties have been acquired by the petitioners after the notification or before the notification.
Yes, my lord, several landowners are there, villagers are there, having their lands since their forefathers.
It will not be there.
It is a public information
you have produced before us.
My lord.
That shows that you have acquired the property in 2010.
My lord.
So it is much after the notification.
My lord. But so far, fact remains that the other villagers of around 10 to 15 mojas are suffering because of this notification. By virtue of this notification.
I don't understand how they are suffering.
My lord.
First of all, when the notification was issued last in 1987, it started there.
Yes, my lord.
1984.
It started in the 84. Thereafter, they have again demarcated the boundaries, and again fresh notification was issued in the year 1987. Thereafter, my lord, in the year 1992, this honorable court directed that you complete the proceeding from section 19 to 25.
What is the direction of this court?
My lord, that order, Annexure 5, my lord, Annexure 5, by virtue of the...
This is the inquiry report. Court
my lord, it may be out of place to mention here that page 31, your lordship.
No, we have got it, but where is the court's order? You says by virtue of the order of the court.
My lord, by virtue of the order of the court, that order I have not annexed, but it is gone out from this inquiry report.
No, sorry. No. This is a secondary evidence. We will not rely to the just review.
But the order was given, my lord, I have, in my pleadings, I have referred to that the order was given.
Court order is a very simple question. You answer simply.
My lord. My lord, para 7, my lord, of the writ petition, on the basis of the writ petition, my lord, this honorable court on 27/8/1992, my lord, directed a notification was issued on 23/4/1984 as at Annexure 1 containing a declaration that the land specified in Schedule A and B could be known as Balukhan Konarko Wildlife Sanctuary, proposed to be set up for the purpose of protection, propagation, development and research on wildlife. The notification was in exercise of power conferred under Section 18 of the Wildlife Protection Act 1972. The Act requires the collector to make inquiry into and determine the existence, nature and extent of the right of any person in or over the land comprising the limit of the sanctuary as laid down in Section 19. As per Section 21, the collector had published the notification in question in regional language containing a proclamation requiring any person claiming any right mentioned in Section 19 to prefer before the collector within 2 months from the date of such proclamation. A written claim in the prescribed form. My lord, we understand from Sri Das, the government advocate, that such an objection on behalf of the petitioner was filed on 19/4/1986, which is yet to be disposed of. A similar matter had come up before this court in OJC number 1118 of 1991, wherein by an order passed on 19/7/91, the collector Puri was called upon to complete the inquiry within a period of 6 months from the date of communication of the order. We are informed that the inquiry has not yet been completed. In this connection, Sri Ratha submits that it may be that the idea of the project has been given up because the project was to be financed by the World Bank, who has not come forward to do so. Be that as it may, there is no doubt that it is high time that the objection filed by the two applicants, one of this case and another of OJC number 1118 of 19, must see its end. Really, Section 22 contemplates expeditious inquiry. Though the time visualized in the aforesaid order of this court has expired, bearing in mind the submission of Sri Das, we allow time till 2nd October 1992. Let this case be placed for admission in the week commencing from 19th October 1992. The author submits that in the meantime, the petitioner may be allowed to deposit rent. We find that such a direction was given in the aforesaid OJC, and so we order that let the rent to be paid by the petitioner be accepted without prejudice to the case of the either party. Let the copy of the order be served on the Sri Das, Honorable Chief Justice and Justice R.K. Patra. Well, petitioner was there, one Hariharananda Giri, Swami Hariharananda Giri. And after this order, by this order, Annexure 5 was submitted. Annexure 5 was submitted, and Annexure 5 is pending before the government, wherein the forest settlement officer has stated that the vast patch of land are to be excluded from the purview of notification under 1987. So unless that this inquiry report is given effect to and new notification is made, well, the petitioners are suffering by virtue of the notification under in the year 1987.
That order has come on. The order that you just read out. 92. In 2011, another order is there.
Another order.
Yes.
Wherein the honorable
come to the reply rejoinder of the Conservator of Forest in paragraph 5.
Reply rejoinder.
191 running page. 191 running page. Para 5.
Para 5. But that in reply to the amendment made in para 4 of the
your rejoinder affidavit has been answered by the Assistant Conservator of Forest.
Yes, my lord.
That para 5.
My lord. That is on dated 26/11/2018.
Yes.
My lord.
That is page 190 to 206.
My lord, I have not page. My lord, it is internal page 2 of the paragraph 5.
Yes.
Paragraph 5, that in reply to the amendment made in para 4 of the rejoinder affidavit, it is submitted that Suresh Kumar Agarwal had purchased land inside Balukhand Konarka Wildlife Sanctuary after its notification in 1984, overlooking the law applicable to the land. As per provisions of Section 20 of the Wildlife Protection Act 1971, cannot possess any land through sale deed inside a notified sanctuary. The purchased land of Suresh Kumar Agarwal exists well within the sanctuary in pillar number 32 and 33. The opposite party number 5, DFO Puri Wildlife Division, did not give no objection certificate in favor of the Suresh Kumar Agarwal. It is submitted that the petitioners are enjoying full usufruct right over their land without any interference from any authority. The land of the petitioners are not covered under the acquisition proceeding carried out under section 19 to 25 of the Wildlife Protection Act as enclosed in annexure 5 of the writ petition by us.
Yes.
But no inquiry was conducted.
Then next.
The plots of the petitioners are well within the movement corridor of wildlife, migration, free movement route, eco-sensitive zone around all the sanctuaries and national parks in the country have been notified by the Ministry, Environment, Forest and Climate Change, Government of India, based on the judgment of the Honorable Supreme Court of India. Accordingly, the eco-sensitive zone has been declared around the Balukhand Konarka Wildlife Sanctuary at a width of 500 meters in the landward side from the boundary of the sanctuary. My lord, I pause for a moment, just I submit that the boundary is to be carved out. It has not yet been carved out in terms of annexure 5, my lord. So therefore, the declaration of the eco-sensitive zone is on a wrong conception of boundary. Thereafter, my lord, your lordship may kindly see, the eco-sensitive zone has to be monitored through a monitoring committee duly constituted as per the notification of the eco-sensitive zone of the Balukhand Konarka Wildlife Sanctuary. Since the detailed list of plots coming within the sanctuary and its eco-sensitive zone, Mauja-wise, were not prepared. Yes. It was declared to stop registration, and DFO Puri Wildlife Division was requested by the third monitoring committee on 22/3/2018 to prepare the list of the plots Mauja-wise coming within the sanctuary and its eco-sensitive zone. The work has been completed and the prepared booklet has been circulated to all concerned in the meanwhile. In fourth monitoring committee held on 4/8/2018, the restriction imposed on the registration has been relaxed to the extent that the permission will be accorded on case-to-case basis. It is relevant to mention here that this Honorable Court in OJC number 1118 of 1991 by the order dated 1991 directed to complete the process of final declaration within 6 months. The forest settlement officer on behalf of the collector Puri has submitted his inquiry report on 1/10/1992 to the government for scrutiny and taking further action. The monitoring committee has no role to play in relation to pending of final notification process, my lord. So notification has not yet been done, my lord. So therefore, the issue is live. So the 87 notification has not yet attained the finality, my humble submission. Unless, my lord.
But by this judgment, the section 18 notification has been made final.
Yes, my lord. Section 18 notification was made final after publication of notification under section 26A of the
this judgment
sanction.
it is final.
My lord, your lordship may kindly see the judgment of this honorable court.
Yes, in the instant case, the judgment that is you have referred in.
My lord, annexure 6, my lord. Annexure 6, your lordship may kindly see. I have referred to the judgment, your lordship may kindly see. Page 100, my lord. In view of the factual position, there is no need.
Come to the judgment in the relevant part that the judgment.
Yes, my lord. The question of quashing, my lord, that is I am coming, my lord. The question of quashing of the annexure 1 and 2, which are included in this petition, do not arise since the proceeding under section 19 to 25 has not been completed within a period of 2 years, as provided under section 25A of the Act. Yes. And declaration of area as sanctuary has not been made as required under section 26A, my lord.
See, 26A kindly refer, that has been inserted only in 1991.
My lord, that
And
is
this notification has come in 1984.
87, my lord.
87.
84 has been given away by.
All right.
87, my lord.
87 it was.
87, after 87, the requirement of law is that the authority has to conduct inquiry under section 19 to 25.
No.
They have completed, your lordship may kindly see.
Now, as Lordship says, in the instant case, but the declaration of wildlife sanctuary as per section 18 is final.
My lordship, your lordship may kindly see what your lordship has held in this, your lordships have held, my lord, that the question of passing of annexure 1 and 2, 87, 84 notification, which are impugned in this petition do not arise since the proceeding under 19 to 25 has not been completed within 2 years, my lord.
But you are insisting for 26A.
My lord, I am insisting, my lord, that the section, report submitted under section 24A has to be acted upon. Unless that is acted upon, my lord, we petitioners and the villagers of different moja are suffering. Because your lordship may kindly see what the forest settlement officer submitted.
You are saying that you are suffering because you have purchased subsequently.
We have not, I am not arguing the matter for only that I have purchased. Several villagers, thousands of villagers are suffering for this. My lord may kindly see. My lord, what is the report of the forest settlement officer? Forest settlement officer has given a report under section 24.
Yes, that is there.
My lord, in view of the above mentioned facts, and the following lands are excluded from the boundary of the Balukund Konarka Wildlife Sanctuary in pursuance of section 24(2)(a) of the Act. So, unless the boundary is carved out, my lord, we are the sufferers. Because as per the inquiry report, our lands are being excluded. But by virtue of the notification under section 2, under annexure 2, 1987, our land, we are unable to use our land. Since 1987, my lord may visualize.
Yes, yes.
So therefore it needs adjudication, my lord. Your lordship, I will show, my lord, the rejoinder, your lordship, I will show rejoinder, what is the principal conservator of forest has written, my lord.
What
page 41, for a moment, my lord.
Section 19 of this Act.
My lord.
Section 19.
Where are you also looked into section 19 of the Act?
Your lordship. And we are not being, if our lands are under the sanctuary, we are liable to be compensated.
That is, I am pointing.
On section 25,
all right.
So therefore we are suffering. Even though we are the landowners, we cannot use the land.
All right, we are giving you liberty to approach the collector for your rights, settlement of your rights, and collector will draw the appropriate proceeding under section 19. Matter ends there.
My lord.
Okay?
My lord.
Great. Collector will decide.
Stipulated period.
This is within minimum 6
months.
6 months is a very too short. I will say.
Your lordship may kindly see the annexure.
You are saying there is a lot of villages there.
Lot of villages are there. Lot of villages.
We give this total up to 31st December of 2024. 1 year time.
Grateful.
Otherwise, it will be the useless direction. You do not know the computation because the survey is to be made. Records are to be made.
Section 19 to 25 exercise may be completed by.
Because you are raising your rights, the sanctuary as declared under section 18. So you can apply to the collector within a period of 30 days from today, and the collector will do the needful for purpose of determining the right and compensation, etc. That will be there.
Grateful. My lord, then it will be confined to the petitioners only. My lord, what I pray, my lord,
it's a public interest litigation, then I will immediately dismiss these things. You say the confined to the petitioner in a public interest litigation.
Petitioners. That is what I am saying.
We will be saying the villagers who
apply.
Nobody within the declared area, my lord, they will be permitted to file when they are right.
Unless there is a publication to that effect, they will not know.
That is why that will make the collector will publish.
That is why your lordship, what I am suggesting, if your lordship will pass the order directing the government for the settlement officer to complete the proceeding under section 19 to 25.
The collector will decide. The process will not determine everything.
Otherwise, the villagers will suffer. My lord, that is my anxiety. I'm drawing any attention for the petitioners. I'm insisting for the villagers, my lord. Villagers of 13 villages are suffering, my lord.
You are saying, but we still have a doubt if the villagers are there to suffer.
They have not.
And have already
They have not yet got their rights. Their lands are.
All right, heard Mr. Ranjan Kumar Raut from council appearing for the review petitioner. We have also heard Mr. Arnab Kumar Behera.
Just Arnav Behera. Just Arnav Behera.
Arnab Behera. Somewhere I find this AK Behera. You typing
There's a
mistake.
different Arnav.
Another person is there.
Yeah, Lord.
Oh, sorry. Arnab Behera, learned additional standing counsel appearing for the opposite parties. This review petition is directed against the order dated
22/9/2020.
22nd September 2022, whereby this court has observed that the challenge to the notification dated 23/4/1984, published by the Forest and Fisheries Department, and the notification dated 1st September 1984, 87 under the Wildlife Protection Act, demarcating the boundaries of the Balukhand Konarok Wildlife Sanctuary is unsustainable, in as much as these notifications held the field for well over 35 years, and now it is too late in the day for the appellant to wake up in 2016 to challenge them. Stop. It has been also observed that there is no valid explanation given for the delay and laches in seeking such relief before the court. Consequently, the court dismissed the writ petition being bereft of merit. Mr. Raut, learned counsel appearing for the petitioner in this review petition, has stated that it will be apparent from the reply affidavit filed by the opposite party number 1 and 5 in response to the rejoinder filed by the petitioner that the land of the petitioners are not covered under the acquisition proceeding carried out under section 19 to 25 of Wildlife Within Protection Act as enclosed in Annex 5 to the writ petition. The plots of the petitioner are well within the movement corridor of wildlife, i.e. migration/free movement route. Eco-sensitive zone around the sanctuaries and the national parks in the country have been notified by the Ministry of Environment, Forest and Climate Change, Government of India, based on the judgment of the Honorable Apex Court. Accordingly, the eco-sensitive zone has been declared around Balukhand Kunarak Wildlife Sanctuary at a width of 500 meters in landward side and from the boundary of the sanctuary. Eco-sensitive zone has to be monitored through monitoring committee duly constituted as per notification of eco-sensitive zone of Balukhand Kunar Wildlife Sanctuary. Since the detailed list of the plots coming in the sanctuary and its ESG, Moja wise were not prepared, it was decided to stop registration, and therefore Puri Wildlife Division, within bracket the opposite party number 5, was requested by the third monitoring committee on 22nd March 2018 to prepare the list of the plots Moja wise coming with sanctuary and its ESG. The work has been completed and the prepared booklet has been circulated to all the concerned in the meanwhile. In fourth monitoring committee held on 4/8/2018, the restriction imposed on the registration has been relaxed to extend that the permission will be accorded on case-to-case basis. Stuff. It has been further stated as follows, quote, "It is further relevant to mention here that this Honorable Court in OJC number 1118 of 1991 by the order dated 19/7/91 directed to complete the process of the final declaration under 6 months. Stop. The Forest Settlement Officer on behalf of the Collector Puri has submitted his inquiry report on 1/10/1992 to the governments for scrutiny and taking further action. Stop. Monitoring Committee has no role to play in relation to the pending of the final notification process, as the contrary allegation being devoid of merits are liable to be rejected. Stop. It is apparent from the said element of the opposite party number 1 and 5 that the process of the final declaration awaiting. Stop. And it has been also admitted that land of the several villages lands of the several villages have fallen within the sanctuary land, which was declared by the notification dated 1/9/1987 within bracket published in the Oriya Gazette. Stop. We are satisfied that the process is incomplete. Stop. But at the same time, we declare that declaration made under Section 18 of the Wildlife Within Protection Act 1972 on 1/9/1987 is valid and within the competence of the state. Stop. But at the same time, the collector has to determine the rights of the persons in and over the land comprised within the limits of the sanctuary. We have gathered that the said exercise has not been taken up as yet, resulting in non-publication of the final notification. Stop. It is really surprising that for such a long term, the rights were not determined by the collector. But it has been stated by Mr. Raut that the person having the land inside the sanctuary are not allowed to get their usufructs or to have the other rights of enjoyment, including possession. So, in such circumstances, we having modified the orders dated
22/9/2020. 22/9/2020.
Order dated 22nd September 2022 and direct the collector to determine the rights of the villages whose land to determine the right of the persons in villages in or over the land comprised within the limits of sanctuary. So such exercise shall be completed within a period of within 31st of December 2024. Stop. The collector shall make a public notification inviting the claim of the persons / villagers in or over the land comprised within the limits of the sanctuary as declared by the said notification dated 1987. Stop. Even the notices shall be served on the individuals according to the information collected by the forest officer. Stop. In the notification, the deadline for submitting the claim shall be 2 months from the date of publication of the notification. Stop. In terms of the above, this review petition stands.
My Lord, one submission, my Lord. Your Lordship said that within the with the notification of 1987, my Lord, but the forest settlement officer under Annexure 5 has given a report for exclusion of that.
No, according to the at the time of consideration of the area, the competent authority may redetermine their area of the forest, and
in terms of inquiry report.
No. During that exercise, the report filed by the forest settlement officer may be considered. It is not extreme. He is even an individual opinion. Stop. In terms of the above, this petition stands disposed of. A copy of this order be furnished to Mr. Behra, Learned Traditional Standing Council, for purpose of transmissions to the district collector Puri, no? Puri. And there also district collector Puri, you right? No?
Item 2, my Lord. 2, it is a, my Lord, writ application where the PKD, Puri Konarka Development Authority has cancelled the building plan approval. So it is a single bench matter, my Lord. But unfortunately, it was tagged up with this writ application, and
this review petition stands detect as on inadvertence. This matter has been listed before a division bench, but it is a matter relating to a single bench of this court. The counsel of the petitioner will be at liberty to mention the matter.
My Lord, no, my Lord. In that case, also similar order was passed.
dismissing the writ application.
No, we cannot review the order of the learned
My lord, that unless that order is recalled, my lord, honorable single judge cannot hear that matter, my lord.
Which order?
My lord, order dated 22
Which has been
9/2022. This honorable
All the
judge has
same
said,
the order.
that observed that in view of dismissal of this writ application, the said writ application is also dismissed without adjudication.
No, why then it is, what is the wrong in that?
My lord, because that writ application, the adjudication has required to be done by the honorable single judge, taking into consideration of the facts and circumstances of the case.
Whether you like to possess that the division bench doesn't have the power to.
No, my lord,
The power still have single judge.
my lord, so then your lordship may observe that in view of the order of this honorable court, this review.
No, in view of the order, the review is also partly allowed.
My lord.
All right.
My lord.
In view of the order passed in the first review petition, this petition also stands partly allowed. All right. A copy of this judgment of the said review is partly allowed. All right. You do one thing. Just make a common judgment. Right?
Yeah,
So there it will be
easier. It will be easier.
And the next, these two matters only.
Two matters.
Was a common judgment, right there, and for the petitioners. And there only say, in view of the order passed, this petition stands disposed of. Okay.